Good morning, student. In today's lecture, we are going to deal with a very informative lesson written by Prahlad Kachare. And the title of this lesson is Introduction to the Right to Information Act of 2005. So, introduction to the Right to the Information Act 2005 is written by Prahlad Kachare. Let's see first of all an introduction of this lesson. Prahlad V. Kachare is a member of Maharashtra State Civil Service working in the cadre of Additional Collector. So Prahlad Kachare is an additional collector. He has worked in various administrative capabilities, it means capacities, in Maharashtra state. He was the director of the Center for Right to Information in Pune. Kachare has authored books. He has written books also. So he has authored books on the Right to Information Act in both language, English as well as in Marathi. He has also delivered, apart from writing books on Right to Information Act, he has delivered, means he has given speeches, delivered numerous lectures and written articles. He has written articles in newspapers also. So written articles on various subjects relating to good governance. So this lesson is most important for you all to know exactly what does it contain. It means what exactly is there. Right to Information Act of 2005. Let's see. The Indian government's website, as you know that our Indian government is also having its own official website. So the government's website on the subject succinctly explains this right. On that government's website, specifically, clearly, as well as concisely, this act has been explained. How it has been explained? Let's see. The basic object of the right to information. It has declared, it has disclosed, it has talked about the basic object of this Right to Information Act of 2005. So the basic object of the Right of Information Act is to empower the citizens. This word is most important. Empower the citizens. Promote transparency and accountability. I have already written these two words over here. Transparency and accountability. So promote. Promote what? Two major things. The first is transparency in the government and accountability in the working of the government. So what is transparency? Transparency means clarity. Everything is clear in all the kind of policies, jobs, works and everything. And accountability means the responsibility. Responsibility of the authority, responsibility of the person who is availing all all those kind of benefits from the government. So government is accountable, as well as the citizen who is availing that kind of facilities from the government is also accountable to that government in the same way. So these two words are most important. The first is transparency and the second one is accountability, where accountability in the working of the government and the most important word here is mentioned in this about all this right, and that is the contain corruption and informed. It is all about to stop the corruption. It is all about to make it more accountable and transparent in all way. So an informed citizenry. Citizenry is a collective noun. It indicates it is the collective noun for people who are living in a country. So they should be informed. They must be informed by the government, by the policymakers, by the authority, that what exactly the things are happening around them. So, to inform the citizenry, so will be better. For what purpose? To make the thing better. So, better equipped to keep necessary vigil. To keep the necessary vigil. What is vigil? Vigil stands for to watch or to look out something. Wherever you find something is fishy, something is malicious, something is against the law, something is unlawful happening, there you can point it out, there you can ask to the government, there you can access some information which is related to that kind of happening, wherever it is happening. So you can ask for that thing. So what is that? It is nothing but to keep on the a strict watch on all these happenings. So citizenry will be better equipped to make them enable to keep watch, necessary vigil on the instruments of government. So it is a comprehensive word, instruments of governments. So instruments of government means all the offices, all the official persons, all the authorities, all the kind of financial activities or financial expenditures, all the kind of the things, whatever going on under the government policies. So instruments of government and make the government more accountable. For what purpose? To make the government more accountable, more responsible. Responsible to the governed. So it must be governed with great accountability, with great responsibility. This act, the Act Right to Information Act 2005, the Act has created a practical regime. This word is most important, regime. For what purpose it has been created or drafted or came into force? The purpose, the main purpose behind the formation of this Act is that was a practical regime. Regime is the way you have not been elected in the government, but even though being a citizen of this country, through this Right to Information Act, you can watch, you can keep watch on all the kind of activities of the government, and you can seek the information about everything, what exactly the government offices are doing in favor of for the government, for the people in the country. So regime through this way, through which the citizens of the country, means any common citizen can ask this question to the government with the help of this Right to Information Act, what they have done in the last time. What has happened with the policy which they had passed in the parliament. You can ask for any kind of information from the government. So, citizens of the country may have access to information under the control of public authorities. So that must be under the control of the public authority. So you can ask for all kind of related information from the government. So let's see what international perspectives it has. As I have already told you that I have written everything on the blackboard. So let's see the international perspective behind the formation of this act, Right to Information Act, which came into force in 2005 in India. So international perspective, the earliest reference to the right to information is found in Sweden. I am repeating the name of the country, Sweden. Sweden, where in the year 1766, Sweden 1766, this year is most important. It was first found in the country, in Sweden, in 1766, a convention granting right to information to all its citizens, all the citizens of the Sweden. It was passed and is treated as, that passed Right to Information Act was treated in 1766 like the world's first Freedom of Information Act. I am repeating it once again. The world's first Freedom of Information Act. When it was passed in 1766. Where? In Sweden. So it was treated as the world's first Freedom of Information Act. The international movement to include it in the legal system. For having any kind of law, we need to legalize it first of all. We cannot have any kind of law directly. We cannot enforce any kind of law directly. We need to have it legalized first of all. So legal system gained prominence in 1946. So it took quite longer period. It legalized in 1946 with a General Assembly of the United Nations declaring freedom of information to be a fundamental human right. You know that we are having some fundamental rights which has been passed by our Indian government, and it has mentioned clearly, succinctly mentioned in our constitution. So it is also considered as, Right to Information Act is also considered as one of the major, most important, essential fundamental human right. It is our fundamental, basic, most important. So fundamental human right and a touchstone. You know what is touchstone? Touchstone is It means relevant, most important. So, touchstone for all other liberties, like all other human rights. This Right to Information Act is considered as, on international level, it is considered as most important fundamental human right, like the other human rights and other liberties which has been given by the countries to their citizens. So it culminated in the United Nations Conference. First of all, in United Nations Conference on Freedom of Information held in Geneva 1948. So Geneva 1948 United Nations Conference held on the basic fundamental human right, and that was nothing but the freedom of information. It was held in Geneva when 1948, which is part of the Article 19 of the International Covenant. So Article 19 of International Covenant means legal agreement. It became a legal agreement, and it has been included in Article 19 of International Covenant on Civil and Political Rights. So it became a prominent part of ICCPR. What is this ICCPR? Civil and Political Rights International Covenant. I stands for international, C stands for covenant, then C once again for civil and political rights, that is ICCPR. So India was, during all this process, all this happening, India was the member of the Commission on Human Rights, appointed by the Economic and Social Council of the United Nations. In those days, even though right now the United Nations and its Economic and Social Council appoint the countries, those who want to be a member of this group. So our India, our country, was also appointed by the Economic and Social Council. Remember these two words, Economic and Social Council of the United Nations, which drafted, means designed, written down, what? Drafted the 1948 Declaration. 1948 Declaration. What was there in the declaration? The declaration stipulates. What does it stipulate? It specifies, it explains, it gives more information. What information is there in that declaration? Drafted by Economic and Social Council of the United Nations in 1948. That declaration stipulates that the United Nations shall promote respect for, there must be respect for and observance of, and everything must be observed. There should be respect given, and as well as observation must be done. So observance of human rights. Observance of human rights. Human rights must be observed. not simply in case of United Nations, but throughout the world, throughout all the nations, and as well as proper respect must be given to all people, or everyone's right to information, or this kind of the RTI, Right to Information Act. So internationally, the right to information, that is RTI, is also called as freedom of information. What is it? Right to Information Act, freedom of information, that is FOI. Then once again, ATI. What is this ATI? ATI means access to information. Every information must be accessible to all citizens of the country. And everyone has a right to seek the information from the government. And it is also called as the freedom of information, that is FOI. Now, this is all about the international perspective, international background behind the formation of this Right to Information Act, which is already called as or known as throughout the world as freedom of information, access to information, that is ATI, and RTI, that is right to information. Now let's see the national history behind the formation or behind the having this law in India. Let's see the national history behind this Right to Information Act of 2005. So I have written first of all some of the objectives of this act, then how this act become a prominent kind of right in India. Let's see its history. So the right to information is a cherished kind of right. How cherished? Cherished means cared. C-A-R-E, cared and given special attention to. A special attention has been given to this right before formation of this right in the country, and special care has been taken by the policy maker or the lawmaker in our country. There is no, for your kind information, in our country there is no express mention of this right to information in the Constitution of India. There is no specifically any kind of written content is available in the Constitution of India in regards of this Right to Information Act. But it doesn't mean so. This act was not mentioned or not having any kind of importance in our country. Yes, it is. Let's how. It is mentioned there in the Constitution of our Government of India. So however, in a number of cases, the Supreme Court, the highest power, the highest authority, the Supreme Court of India has ruled that when sometime there is no certain kind of succinctly explain any kind of law or any kind of that kind of the rules or regulation in our Constitution of India, in that case Supreme Court can suggest to the government to come ahead and form this kind of law, to come ahead and think about this kind of happening and take the right decision. So here the Supreme Court of India has ruled that right to information flows from, flows